Good morning, sir. Can you see and hear me?
Yes, I can. Thank you.
Thank you. If I may call Mrs. Williamson.
Yeah.
I do solemnly, sincerely and truly
I do solemnly, sincerely and truly
declare and affirm
declare and affirm
that the evidence I shall give
that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
and nothing but the truth.
and nothing but the truth. Thank you.
Williamson, as you know, my name is Sam Stevens and I ask questions on behalf of the inquiry. Could I ask you to state your full name, please?
My name is Teresa Mary Williamson.
In front of you, there should be a bundle of documents.
Yes.
If I could ask you, I think it's the smaller bundle in this case, to turn to that and you should see it in one of the first tabs, a copy of your witness statement.
That is correct.
Firstly, thank you for giving that written statement to the inquiry and for giving oral evidence today. Can I just check with you that that is a statement dated 15th of August 2023, running to 36 pages?
Yes, the statement's 34 pages, and then there's 2 other pages
Yes.
of index.
And on page 34, there should be your signature.
Yes.
And are the contents of that statement true to the best of your knowledge and belief?
There's just one thing I do wish to correct.
Yes.
When I was reading the statements and exhibits last night, I realised that the person who actually made the decision on prosecution, there was one for each business, and I think it was the person called the National Investigation Officer for the Post Office Limited. In the past, it had been the retail or the area managers, but by the time I think this case was being dealt with, I think there was one person making the decisions on prosecutions within each business. So I think that was not quite correct when I made that statement, but I just misremembered that.
I see. So subject to that correction, the remainder of the statement is true to the best of your knowledge and belief?
Absolutely.
For the purpose of the record, that statement is WITN 08680100. That statement now stands as your evidence to the inquiry. I'm going to ask you some questions about it. The first one is just a point for clarification. You're now Mrs. Teresa Williamson.
Yes.
At the time, your last name was Berridge, is that correct?
Yes, that's correct. That was my professional name as a solicitor, but I now use my married name.
Starting then with your career history, you qualified as a solicitor in 1990.
That's correct.
And on qualification, you worked for a solicitor's firm practicing criminal law.
Yes, I did.
In your statement, you say that your caseload was almost exclusively involved defending individuals who have been accused of criminal offences. You go on to say that you had a very small number of private prosecutions relating to dangerous dogs.
Yes.
In terms of private prosecutions, when you say a very small number, how many are we talking? Less than 10? Fewer than 10?
Yeah, fewer than 10. It was 1 or 2, I think.
And when you were prosecuting those cases, did you advise on charging decisions?
Yes.
And when you were advising on charging decisions, would you apply the code for Crown prosecutors?
Those were completely private prosecutions. I must admit, I don't think I did, when I was doing those private prosecutions, apply for the Code for Crown Prosecutors. But all the cases I dealt with at Royal Mail as a prosecutor, I did apply the Code for Crown Prosecutors, yes.
We'll come to that now. You joined the Post Office in 1992.
Yes.
So 2 years after qualifying.
Yes.
You said that your role involved prosecuting cases. Was the prosecution of criminal cases your sole area of responsibility, or did you have other casework as well?
I did a little bit of advice work, yes.
Advising on what matters?
So, all sort of like criminal type issues, yes.
So very much within the criminal law team and focused on criminal practice?
Yes.
You say in your statement that at the time of joining, there were around 10 lawyers in the criminal law team. Of those, how many would be working on prosecutions against sub-postmasters for theft, false accounting, or similar offences?
When I first started working at the post office, all lawyers in the criminal law team, apart from the assistant director, later called the head of the department, the team leader, everyone would prosecute a mixture of cases. So some would be Royal Mail cases, some Post Office Limited cases, and some might be parcel force or cash handling and distribution. So it was a real mix at the beginning, although later I think it changed to people tended to do more of one kind of case.
When you said everyone except what became the team leader,
Yeah.
when you joined, were you referring there to Roger Williams?
No, I was thinking about Mike Heath, who
Mike
was the assistant director, the head of the criminal law team.
So do you recall what Roger Williams' job title was?
So he was the principal lawyer, and I think when I first joined, he was doing a mixture of cases, yes.
And Mike Heath, you said, sorry, could you just repeat his job?
So Mike Heath was the assistant director, and he oversaw, he managed the team. I don't know whether he had any of his own caseload. He might have had the more serious cases, but I think more managerial role and higher level advice work on criminal law.
When you joined, your job title was lawyer.
Yes.
You became senior lawyer or promoted to senior lawyer
Yes.
in 95, 96.
Yeah.
Roughly how many lawyers and senior lawyers were there as a proportion within the team?
So when I first joined the criminal law team, I think I was the only lawyer. Everybody else was a senior lawyer. And then when I became a senior lawyer, from time to time, I think we did have article clerks came and joined us in the team. And at some stage also there was a junior lawyer came and joined us in the team. But I can't remember the dates.
In terms of the title senior lawyer, did that simply reflect that you'd been at the business for a period of time, or was it a substantive promotion?
It was a substantive promotion. I remember that in the run-up to me becoming a senior lawyer, I was purposely given cases, more challenging cases, so that I could prove that I could deal with more challenging cases on my own.
And when you say more challenging cases, can you recall what type of challenging, or why they were more challenging?
I guess either because there was more paperwork or because financially there was more involved. So one case I particularly remember was a case where I think $500,000 was involved, but that was more of a Royal Mail case. It was someone trying to undercut the sort of like the Royal Mail, the universal service provision. So it's a more complicated case, and I remember dealing with that in the run-up to becoming a senior lawyer. That was a case that evidencing that I could deal with more.
So, and in terms of your line management, you say you reported into Roger Williams initially.
Initially.
And then that became Rob Wilson later.
Yes.
And did Roger Williams or Rob Wilson report into Mike Heath?
They did. In fact, many ways, we all reported into Mike Heath, but they would have been the people who would have done, say, for example, my appraisal. They would have been the people that I went to first if I had any issues in cases.
And can you recall to whom Mike Heath reported?
So initially, he reported to, well, he did all the way throughout, reporting to the solicitor to the post office. And when I first joined, it was a man, and I'm really sorry I can't remember his name. But after a period of time, it was a woman called Catherine Churchyard.
To what extent did the solicitor to the post office have involvement with the day-to-day running of the criminal law team?
So Catherine Churchyard?
Yes.
Very little. It was Mike Heath who was in charge of his team. You really only had dealings with Catherine Churchyard In fact, actually nice dealings. I remember when I got pregnant, I got a present. But I didn't really have much dealings with her at all.
When you were promoted to be a senior lawyer in 95 or 96, you say at that stage the level of supervision over your work would have been minimal.
Yes.
Can you expand on that? To what extent was it supervised?
When files came in from the investigators, they always went through the desk of the team leader or had been the assistant director. And he would have allocated cases, or if he had wanted to, I don't know whether he did or not, whether he ever had a look in cases just to see things were going properly.
And you say at that time you took over a supervisory role. How many people did you supervise?
In total, 3. 2 trainee solicitors, article clerks, and 1 junior lawyer, but at different times.
And the article clerks and the junior solicitors, would they have their own caseload?
Yes. Well, I don't think the article clerks did. The junior lawyer did, but I don't think the article clerk did. I think she worked more like one of the junior legal executives, helping with more administrative things or doing specific tasks on the case.
And would a junior lawyer ever, for example, give charging advice independently without supervision by you?
So the junior lawyer, if I'd been supervising them at the time and I hadn't been there, they would have had to have run it through another lawyer in the team, a senior lawyer in the team, yes.
So we're now at 95, 96. You said beforehand that you had a variety of work of all different types of cases. By 95, 96, were you noticing that you were getting more of a particular type of case? And if so, what type?
So not so much 95, 96. 95, 96, I think it was still a wide variety of cases, but it was after I returned from maternity leave, later on, I can't remember exactly when it happened, that we got more restricted cases, more towards the 2000s, I think.
And when you say more restricted with the cases, what type of cases were you getting more regularly at that point?
I think, I can't remember which cases I was mainly allocated to, but I think I did get a fair few Post Office Limited cases, yes.
And to what extent, or how regularly would you have a case against a postmaster for charges of theft or false accounting?
And that's something I really can't remember. I really cannot remember the number of the cases I had, the names of the defendants or the issues in the cases. I can only comment on what I've seen. It's just so long ago.
Well, we are going to, in due course, turn to look at one of those. But before we do, a few more general questions. You refer in your statement to there being a slight reduction in staff numbers. We refer to 10 lawyers at the start, and I think by the time you left that you say roughly 8 lawyers. So
Yeah.
are we talking simply a reduction of 2 or...
In fact, when I was thinking about it last night, I was trying to remember the order in which people left. So there were 2 rounds of redundancies. I think at the first round of redundancies, Mike Heath left. I think also, I can't remember whether both Joyce Gibson and Nicola Knight went, or whether they went on 2 separate redundancy rounds. Tony Brentnell retired and went to Canada. But I can't remember quite the order that people left and whether some people left after I joined the employment team. But all I can say, it did reduce. But I can't remember the numbers and when.
So a reduction in numbers over time. Do you recall whether the amount of work that the criminal law team were expected to deal with, whether that increased or decreased over the same period?
To me, it felt about the same.
And are you aware as to whether the size of the investigative team in the security department, whether that grew or shrank at the same time?
They also had a round of redundancies, so it was voluntary redundancies. And I think a fair few investigators went on the first round of voluntary redundancies, yes. So it was I seem to recall that both the criminal law team and the investigations team were shrinking, and the business was happy with that.
I want to just briefly look at the working environment. In your statement, we don't need to go there, but for the record, it's firstly paragraph 18. You say, aside from supervision of the articled clerk and more junior lawyer, each member of the team tended to work autonomously on their cases, and there was generally very little collaboration. And you go on to say at paragraph 13 of your statement that the team regularly went for lunch together, but that was to have social conversations, not talk about the cases. So this doesn't sound like it was a case of a personality clash within the department. Is that fair?
Yeah.
You hesitated to answer.
Yeah, I did hesitate, didn't I? I don't think I was the most popular person in the team. I'll accept that.
So when you say that people working autonomously, was that you didn't speak to other people about your cases? Were you aware of other people speaking about their cases to each other within the department?
Not really. I mean, I do recall that it was all very autonomous, and I guess partly because we were dealing with different cases. I think also because I think once you were a senior lawyer, you wanted to appear that you could deal with your own cases and didn't have to keep asking for help. It just wasn't a collaborative team. And the reason I say that, when I moved to the employment law team, it was much more collaborative.
But for example, in say the criminal law team and say there's a number of people prosecuting sub-postmasters for, let's just say theft in this case. And let's focus after Horizon.
Did you say after Horizon?
After Horizon, yes.
Okay.
The source of evidence is very similar, that it comes from the same computer system. The ways of working and the practices are similar or the same, should be the same because it's in the same company. To what extent do you think it's surprising that when there are those similarities, people didn't communicate or discuss how they approached other cases to try to share learning?
It is surprising, but that's how it was.
Do you know why?
Do I know why? It was just the nature of the organisation, I think.
And do you think that was caused by the way you were managed?
Possibly.
How would you describe the management style of, well, let's start with Mr. Heath. How would you describe his management style?
He was a lot more collaborative. You really felt that you could go in and ask him anything.
And who took over from Mr. Heath directly?
Rob Wilson.
Rob Wilson.
Yeah.
And how did things change when Rob Wilson took over?
He was a quieter, more private, more reserved person. It didn't feel quite so much an open door to go into his office.
Do you think that more broadly affected the level of collaboration within the team or not?
Certainly, as far as I was concerned, yes.
On reflection, do you think it would have been helpful if the team had been more collaborative or not?
Absolutely.
Why?
Well, I've worked in other organisations and I've been a more senior leader in other organisations, and I realised that collaboration and facilitation adds to the strength of a team, and you can achieve far more when you collaborate. But that's with the benefit of hindsight, looking back to how things were.
We're talking here purely within the criminal law team. To what extent were you aware within Post Office of any sources of advice or support for IT issues?
So, what if we had IT problems
Let me
ourselves?
rephrase that. If a case threw up an issue with a computer error or an IT issue, were there any resources of which you were aware in the Post Office itself that you could use for assistance or to discuss the matter with?
Okay, so if it had come up in one of my post office cases, I would have gone back to the investigator and asked him to get a statement from the relevant person, yes.
So you would have left that for the investigator and you yourself wouldn't have approached...
Absolutely, because it was the investigators who gathered the evidence, and then the criminal law team advised on the evidence, and then the National Investigation Manager made the final decision on whether there should be a prosecutor. So there was a very clear delineation between who did what.
I want to move now to look at the slight difference in role you had, because before you were in private practice in a solicitor's firm.
Yeah.
And one thing is you went from mostly defence to solely prosecution.
Yeah.
And secondly, you became an in-house solicitor,
Yeah.
where your employer was also your client.
Yeah.
Presumably, as an in-house solicitor, you accepted you still had your ordinary duties to the court
100%, yes.
and to act with independence and integrity.
Absolutely.
And to what extent, if at all, did you find it was more difficult to comply with those duties as an in-house solicitor?
I thought it was easier, actually. It's very hard as a defence solicitor sometimes when clients were trying to get you to, they might tell you one thing and then they wanted to put forward a different case. In some ways, it was much more challenging as a defence solicitor because I trusted that within the post office, if I asked for evidence to be obtained, that it would be obtained. I trusted that if there was unused material to be disclosed, that would be provided to me by the investigator. So I thought at the time, until I read the article in Computer Weekly, that it was easier.
Well, let's just go out of order a bit because you've raised this. You say that's what you thought at the time.
Yeah.
What are your reflections now?
Looking back, knowing what I know now, since I read the article in Computer Weekly and also from reading the judgments in the Bates case and the Hamilton case, I realised that there was a lot of material that wasn't disclosed to me and things that I should have known about I didn't know about. And that makes me angry and sad.
Can you expand on why that makes you angry?
Because we should have been told these things. So, for example, I understand there were discussions at board level about the reliability of the Horizon system, and that was not filtered down to the criminal law team.
And if it had been filtered down, speaking purely for yourself, what do you think you would have done differently?
Well, if I'd known that the system was not operating properly, I would have insisted that the relevant statements were obtained from Fujitsu to explain how the system was working, or if it wasn't working properly, in what respects it wasn't working properly.
That statements, would you have done anything in respect of documentation?
In what sense?
Sorry, so you would have obtained statements from Fujitsu. Would you have looked for any, or asked the investigators to look for any further documents related?
Absolutely, yes, definitely.
Did you ever feel at any point under pressure from investigators to pursue a prosecution?
The main one I can think of was a case prior to Horizon where there was an issue in relation to unused material, and I sent off the investigator to go and search a big warehouse looking for paid orders. There was pushback from him in that case, and in fact we did actually have to withdraw that case. So that's the case that I remember where there was the biggest pushback, but that was a pre-Horizon case.
And I believe from what you said, that was withdrawn, the case.
That case had to be withdrawn. And if I'd ever had any Horizon cases where there were that sort of issue, where I felt there was unused material available that was not being disclosed, and there was either a refusal to disclose it, or I was being told it couldn't be found and they weren't going to withdraw the case, I wouldn't have stood for that.
Staying on the subject of acting as an in-house solicitor, I want to talk about instructions. The phrase can be used in two ways. Firstly, a lay client can give instructions to a solicitor. And secondly, a solicitor can pass on those instructions to counsel.
Yeah.
As a solicitor in the criminal law team, did you ever provide instructions to act where you made the decision on the behalf of the post office as lay client?
No.
And we've already covered in your evidence, actually, the charging, who made the charging decision, so I don't need to take you to there. We can move on instead to some of the processes. When you joined, I'm focusing purely on cases against sub-postmasters here for theft and false accounting. Obviously, when you joined, such cases wouldn't have relied on Horizon data because that didn't come until later.
Yeah.
Can you just summarise briefly what accounting data was used in those cases prior to the introduction of Horizon?
Gosh, I've got to... What type of case are you talking about? There were so many different types of cases. So
if it was a sub-postmaster who is alleged to have stolen cash from the post office, a similar case to Crown and Brennan, which we'll come to shortly, that type of case.
Okay. So I guess the starting point would probably be, usually it's an audit had taken place at the sub-post office or the branch post office. And I'm really trying to remember a long way back now. It's really hard to remember. There would often be paperwork, statements and exhibits from the DSS paid order unit in Lisa Halley. There would be statements from the officers, the investigating officers. There would be the record of tape-recorded interview. If the person had voluntarily agreed to be searched, whether anything had been found on them. If anything had been found anywhere in the office, in an untoward place.
And in terms of accounting records,
or accounting records.
The cash account by the...
Yeah, there'd be a cash account for the sub-post office. And with the documents that used to get sent off to the paid order unit in Lisa Halley, I'm trying to remember what kind of documentation went with it. I can't remember the name of the form, but I'm sure there was a form, probably a handwritten form that went with the documents to Lisa Halley.
To what extent did the investigation focus on, pre-Horizon, focus on trying to establish where alleged stolen funds had gone? So whether to the sub-postmaster or otherwise?
Well, I think in all cases, pre and post, there'd be... If the problem was people couldn't be searched unless the police were involved or unless they voluntarily agreed to. So if they voluntarily agreed to be searched or the police were involved, the person might be searched, or say their handbag or something like that. There was often questions asked about their accounts, their bank accounts or things like that. Just depends on the case. It's really hard. It's such a general question, it's really hard to answer.
Let me ask you one last general question, though, which may be hard to answer, but we'll see. Before the implementation of Horizon, if a discrepancy had been identified leading to an investigation, can you recall to what extent, if at all, or with what regularity, sub-postmasters would say that any alleged discrepancy wasn't due to dishonesty, but due to errors in the accounting documentation?
think it happened before Horizon, it happened after Horizon.
Do you recall if there was a change in frequency of those issues
No,
being
I
raised?
can't recall.
Could we turn to your witness statement, please? It's page 7, paragraph 19. Sorry, wrong page, page 6. Thank you. Paragraph 19, you set out or summarised 10 steps that you say were typically involved in a prosecution, or your involvement, I should say, sorry. And the first is reviewing the case file, and the final sentence says, on reviewing the file, my focus would have been on considering the strength of the evidence in the case in accordance with the evidential test in the Code for Crown Prosecutors, which was used by the criminal team to assess whether a case met the threshold for prosecution or not. Do you recall what, if any, guidance there was available to you when you joined the Post Office on applying the Code of Crown Prosecutors?
I just remember that we always applied the Code for Crown Prosecutors, and we all had a copy of the Code for Crown Prosecutors, and I always used it when I was thinking about cases.
And what was your understanding of the evidential stage of the full code test?
Right, so the starting point, is there sufficient evidence to afford a realistic prospect of conviction? So that is whether there'd be more than a 50% chance of success. So there'd be enough evidence on each of the individual aspects of a crime, so the actus reus and the mens rea, to afford a realistic prospect of conviction.
Could we turn the page now, please, to step 3? And this is where you're talking about drafting a written advice to a regional or area manager. We've spoken how that may be someone different at different
Yes.
points, but you drafted the opinion on why a prosecution is or is not appropriate in accordance with the Code for Crown Prosecutors, with a particular focus on whether there is a realistic prospect of conviction. Why was there a particular focus on that aspect on the first stage?
Because if the criminal lawyer didn't advise there was sufficient evidence to afford a realistic prospect of conviction, unless further evidence was obtained, the case would fall, then it wouldn't go any further.
You say, if I advise that there was a realistic prospect of conviction, I would have also included my opinion on the likelihood of success in this advice, along with the relevant charges and a summary of facts to be served on the defence. If I advised there was not a reasonable prospect of conviction, the case would have been brought to a close at this stage, and you say you were only providing an opinion. To what extent would you have offered an opinion on the public interest aspect of the test?
So that came second. So first of all, we'd advise whether there's sufficient evidence to afford a realistic prospect of conviction. Then, if there was sufficient evidence to afford a realistic prospect of conviction, you would possibly advise on the likelihood of success. So whether there was a low prospect of success, so more than 50%, but not particularly high, or a moderate or a high prospect of success. And then, in relevant cases, say, for example, maybe it was a really old accused person who was maybe, 85, something like that, and it was maybe a small amount that had been stolen, then you might be advising whether it was in the public interest to prosecute such an old person. or if it's a very young person who maybe was working as an assistant in a, or maybe a young postman maybe who had stolen some mail, but maybe they'd only stolen one letter and they were very young, they'd only just started. Again, that might be a public interest for not prosecuting.
It sounds like there what you're describing is you would proffer advice if it appeared on the face of the case that there were countervailing factors that suggested that a prosecution wasn't in the public interest.
Yes.
So was the default position that you wouldn't advise on the public interest unless on the face of the case there was such countervailing factors?
Yes, I think that's correct, yes.
And in the case of a sub-postmaster accused of dishonesty, of theft, what, aside from the factors you set out there, were there any others that you may take into consideration which would tend or point away from a prosecution in the public interest?
I think I would often, if it's one where I felt a bit uncomfortable about recommending prosecution, I would read through the Code of Crown Prosecutors and see whether there are any factors discussed there that might tend away from recommending a prosecution.
To what extent, just trying to clarify this point on the prospects of success, so say one that's 55% and one that's 70%.
Yeah.
To what extent did the variation in prospects of success there factor into the public interest stage of the test as you applied it?
Less so.
Please, can we bring up a document? It's POL 000-30659. It's a document titled Post Office Internal Prosecution Policy, brackets dishonesty, and it's dated December 1997. Under heading 2, it says there is no single statement of current policy, but it can be summed up as normally to prosecute all breaches of the criminal law by employees which affect the post office and which involve dishonesty. Was that a fair reflection of do you think that's an accurate reflection of what the policy was up to December 97?
I'm struggling to read with the glare. Can you point me to the paper version, please?
Oh, of course, yes. It should be in the bundle, the larger bundle, E4.
E4.
It would be right at the back of that. I think the last document within it.
Thank you, that's better. Right, there's no single statement of current policy been summed up as normally prosecute all breaches of criminal law by employees. My reading of that is that the Code of Crown Prosecutors is still overarching. So if there was insufficient evidence to afford a realistic prospect of conviction, it wouldn't be prosecuted. It was only if there was sufficient evidence to afford a realistic prospect of conviction, then you were moving on to the next stage. Would you look at this? So I read, because this is a document not written by a lawyer. This is a document written by the head of investigations, Andrew Wilson, who's not a lawyer. So he's not articulating the Code of Crown Prosecutors. But I would always have read this through the lens of the Code for Crown Prosecutors. So that would, in effect, trump this document.
And do you think the way you worked,
Yes.
do you know if that's similar to how other people in the team worked or not?
I think when I was there in 2002, 2003, that would have been the way people would have worked. And if they didn't, I'd have been shocked and disappointed with them.
The point that there was no single statement of current policy before, was it, from your evidence, is it that the sort of single policy in practice was simply to apply the code for Crown prosecutors?
Certainly in the criminal law team, when we were advising on the evidence, it would have been to apply the code for Crown prosecutors. This document, I think, I'm not quite sure who the audience for the document was meant to be, but my reading of it was that it was almost like trying to find more cases where the public interest would have applied. So it's more about not prosecuting everybody. So, for example, there's a lot of talk about raw mail cases and willful delay. I think it's much more aimed at that and having fewer prosecutions rather than more prosecutions.
Do you have any recollection of what led to this policy being
No,
done?
that's what I don't know. So I don't know why it was drafted, because it's a Security and Investigations Team document, Andrew Wilson. I know he says that lawyers have reviewed it. I suspect that would have been Mike Keith, the Assistant Director, but I don't know who the target audience was for. But I don't think the target audience was necessarily so much lawyers as people within the business. And maybe, I don't know, possibly the people making the decision whether to prosecute or not. But I don't know, I'm guessing.
But as I said, for the purpose of your practice, you were led by the code for Crown prosecutors.
Absolutely, that came first, always.
Your evidence earlier was that you didn't speak much about practice with or collaborate with other people. So whilst you've no reason to believe that other prosecutors, I'll rephrase that, other lawyers in the criminal law team use this document rather than the code, you don't have first-hand knowledge of that.
I don't have first-hand knowledge, and that doesn't sound right. It was always the code for Crown prosecutors came first, and we all had copies of it, so I can't see why that, in anyone's mind, would trump the code for Crown prosecutors.
That document can come down, thank you. Moving then to the introduction of Horizon, you say in your statement that you likely became aware of Horizon as something to be introduced in the late 90s or early 2000s. You say that you didn't give it a lot of thought at the time, and you also say, we don't need to go there, but at page 12, at the top of your statement, you say, I knew it was a computerised bookkeeping system designed to assist sub-postmasters with the processing of various payments and also balancing on a weekly basis. That broad understanding, can you recall where that came from?
Sorry, no.
So previously, the cash account before Horizon was prepared by the sub-postmaster, and the record of transactions, so the data from which the cash account was drawn, that was created and kept by the sub-postmaster as well. Do you agree with that?
Or, say, for example, if it was in the branch office, different people might have prepared different bits of it. And I think that's what happened in... No, that's a Horizon case, no. But it may have been assistants might have prepared certain transaction records.
Yes.
Yeah.
But for a sub-postmaster in an agency branch...
On their own.
On their own, they maintain the record of transactions and they're responsible for the accounting, creating the accounting documents.
Yes.
And so if there's any queries about the integrity of the transaction, the record of transactions, or how the cash account was put together, appreciate this, the privilege against self-incrimination, but the sub-postmaster could be asked questions about how the transactions were kept and how the cash account was created.
Yes.
With Horizon, Horizon stored the transactions itself,
Yes.
and Horizon created the new cash account.
Yes.
And so, do you accept that the provenance of the data, or the accounting data upon which prosecutions against sub-postmasters for theft, the provenance of the data on which those were based, fundamentally changed with the introduction of Horizon?
Yes.
And the integrity of that data depended on the computer, or Horizon, rather than the sub-postmaster?
Sorry, can you say yes or no rather than nodding your head?
Sorry, I'm thinking. Sorry,
I know sometimes you're nodding your head and it doesn't go on the transcript, so if you could just say
right.
verbalised. Thank you.
I'm not answering, I'm thinking. Could you ask me the question again, because my concentration's gone?
Yeah. The integrity of the data depended on the computer, namely Horizon, rather than how the SPM stored the records or totted up the account.
Yes.
So, with that substantial change, do you recall any discussion within the criminal law team about how the introduction of Horizon would affect prosecutions to sub-postmasters when Horizon was introduced?
There probably was, but I cannot remember any specifics.
As a lawyer, had you worked, prior to Horizon, had you worked on any cases which involved relying on data produced by a computer to prove a fact?
I remember a defence case where I had involving bookies.
So do you recall now the terms of the now repealed Section 69 of the Police and Criminal Evidence Act?
Please remind me, it's a long time ago.
So Section 69, I'm paraphrasing here, but set out that in order for a document produced by a computer to be admitted as evidence of a fact stated therein, the prosecution had to prove, amongst other things, that there were no reasonable grounds for believing that the statement was inaccurate because of improper use of the computer, or that at all material times the computer was operating properly, and there was another exception for if it wasn't operating properly. Were you aware that the Post Office made submissions to the Law Commission on the proposal to repeal Section 69?
When was that? What year?
It would have been in the, I think it's the late 90s. I'll get a specific date for you, but it's the late 90s.
Late 90s. I don't know. I can't remember. I'm sorry.
Would you remember if you'd been involved with that?
I really don't know. Sorry.
Do you accept that if the Post Office had been aware of any concerns as to the integrity of Horizon data, that should have been disclosed to sub-postmasters in cases where the data relied on was generated by Horizon?
Absolutely.
Could we please bring up page 12 of your statement? Looking at the end of paragraph 26, you say, I recall that at the time the system was being rolled out, there was a general message within the organisation that it was a sophisticated and high-quality technology. Do you remember where that message came from?
No.
The inquiry has heard a significant amount of evidence about the difficulties faced in the rollout of the Horizon IT system from 1999 and 2000 and onwards. Were you aware of any of those difficulties?
No.
You say in your statement that you always assumed that Horizon was reliable and was never given any reason to doubt the accuracy of the technology. And you say, paragraph 28, I did not ever think to question the accuracy of the technology to properly understand the mechanics of the system. What was the basis for your reassurance, your assurance that the system was accurate?
I can't remember now. I guess because I personally don't think I'd had any cases where there were any issues with the system working properly, and I wasn't aware of any cases others might have had. So I just assumed that it was working properly.
Can you recall anyone in the criminal law team standing back and saying, well, hang on, our prosecutions are now going to rely on data from this system. We need to satisfy ourselves that it's accurate and that it produces reliable data?
No, I don't remember that.
Why do you think no one asked that question within the team?
I really don't know. I've got no recollection of that.
We've discussed that the introduction of Horizon would lead to significant changes to the way in which prosecutions were brought. Can you recall any change? So I asked you earlier about whether there was a discussion of how prosecutions would change.
Mm-hmm.
In practice, do you recall any change to the way in which prosecutions were brought against postmasters for theft or false accounting, such as the type of evidence that was relied on?
There were different schedules that would have been run off the Horizon system that became part of the evidence, yes.
Do you recall ever being involved in a case post-Horizon where the defendant alleged that the data was inaccurate? The data produced by Horizon was inaccurate?
No, I don't recall that.
Were you aware at all of post officers' contractual rights to data or information held by initially ICL Pathway or Fujitsu to support prosecutions?
I do know that the post office had the right to get that information, and the reason I know that, when the agreement was being negotiated, I did have a very small dealing, I think through one of my colleagues in the corporate or commercial team, of strongly recommending that there should be a clause within the agreement saying that Post Office Legal Services or the investigators could get access to statements and data without having to pay lots of additional money. So I saw a very small part of, I think it was either a draft agreement or a service level agreement about that, but I didn't see the whole agreement because it was dealt very much within who needed to know what, and that was through a colleague in the company and commercial team.
Can you recall the name of that colleague?
No.
Do you recall roughly when that was?
It would have been about the time that the agreement was being, when it was being negotiated.
You were, at that point, a senior lawyer.
I was, yeah.
Were you the only person consulted in respect of that, those contractual matters in the team?
I don't know, but I was the person who was asked about that particular clause. Mm.
And your advice, as you said, was to ensure that data could be obtained without significant cost.
Absolutely.
Did you see the final version of the agreed clause?
I don't know if I did or not.
When you came to prosecute cases, or when you advised on prosecutions later, was your working understanding that you could have obtained such data from Fujitsu if necessary?
Absolutely, 100%.
Was that common knowledge within the criminal law team?
I think so, yeah. I'd be surprised if it wasn't.
And what type of data did you understand you could access?
I got them to draft it very broadly so that it was anything that could ever come up in the course of a criminal prosecution. I wasn't thinking about any particular type of data. I just wanted the post office had an open-ended way of doing this, because I could probably conceive the kind of cases at that stage it would come up in.
The inquiry's heard evidence about audit data called ARQ data. Were you aware of that type of data at the time you were involved in prosecution?
I only found out about ARQ data either through reading the Computer Weekly article in 2009 or one of the cases, either the Bates case or the Hamilton case.
So presumably you didn't obviously use this data in any of the prosecutions in which you were
No, because I
involved.
didn't know it existed until 2009.
Why do you think, as a lawyer who'd advised on what types of data the Post Office should be entitled, can you explain or proffer a reason as to why you weren't aware of the availability of ARQ data?
I didn't say I knew the types of data, that I just said everything. I requested it broadly because I didn't know what the data was, and I just wanted it to be belt and braces, that we could get anything we needed, even though I didn't know what type of things it might be needed for. That's just being careful, trying to get the best for your organisation.
I want to just quickly deal with training. You say that there was training available for lawyers in the criminal law team, but that you weren't initially able to attend it. Do you remember who in your team was responsible for overseeing your training or professional development?
I guess two things. I think in relation to getting your, I think it was CPD points in those days, you were personally responsible for ensuring you had all your CPD points or more. In relation to your sort of like personal development in a more general way, which could be wider than just getting your CPD points, that was between you and your team leader, your manager, and that's something that would be looked at appraisal time.
We know in your case you didn't have the Horizon training,
Yeah.
But can you recall whether or not that training was intended to be compulsory for members of the criminal law team?
I think it's one of those things that was intended to be compulsory if you were there, but if you were not there for any reason, obviously it couldn't be compulsory. And the post office wasn't the kind of horrible employer that said if that training was on that date but your child was sick or it's a day you're meant to be looking after your child, that you had to attend on that day. I just hope that it would be reorganised later, but I don't remember attending it.
Do you consider it problematic to have received no training on Horizon, but to then advise on prosecutions in which Horizon data was a source of evidence?
If I had had any opportunity to attend the Horizon training, I would have. But I can't remember why I couldn't. I remember feeling peeved that I couldn't because it wasn't on a day I could. But I'd have wanted to, and I was never the kind of person who avoided training. In fact, I even went on courses on Saturdays. So I'm the kind of person who loves training and sees the benefit of it. So if I could, I would. And sadly, I couldn't for whatever reason I can't remember.
So I think that's a good time to pause, actually, before we move on to the case study.
Yeah, by all means. Is 15 minutes sufficient for everyone?
Yes, sir, thank you.
So Well, I make it 11:01, so just after 11:15, Mr. Stevens, yeah?
Thank you, sir.
Fine.
Good morning, sir. Can you see and hear me?
Yes, I can, thank you.
Thank you. I said we were going to go into the case study. There's just one point I want to clarify. In your evidence this morning, or early this morning, you said, I understand there were discussions at board level about the reliability of Horizon. Can I ask, when did you become aware of that?
I think I found that out through one of the cases. I think it was either the Bates case or the Hamilton case. The transcripts.
But just to confirm, your evidence is at the time.
Definitely at the time, I did not know.
I want to turn then to the case of the case study of Crown and Brennan. Lisa Brennan is a core participant in these proceedings, and the inquiry is examining it as this prosecution as a case study. It's the first time that the inquiry will look at this case study, and I want to turn first to the judgment of the Court of Appeal Criminal Division in the case of Crown and Hamilton, where Miss Brennan's conviction was quashed. Please can I turn to Pol 00113278. It's in your bundle at B36. B for Bravo, I should say. And please can we turn to page 59, paragraph 286.
Yes.
To introduce the case, I'm going to read a substantial portion of this. It says, on the 4th of September 2003, in the Crown Court at Liverpool, before His Honour Judge Phipps and a jury, Lisa Brennan, who had become a post office counter clerk when she was 16 years old, was convicted on 27 counts of theft, representing a shortfall of £3,482.40. She was acquitted on 5 further counts. On 6 September 2003, she was sentenced to 6 months imprisonment, suspended for 2 years. On 11th May 2004, her appeal against conviction on the basis of inconsistent verdicts was dismissed. As a result of the proceedings against her, she was forced to file for bankruptcy. Post Office decided to pursue criminal charges against Miss Brennan in relation to events in 2001, close in time to the rollout of Horizon. According to the limited available documentation, the prosecution case was that when she paid out cash for allowance and benefit vouchers, she removed more cash than was permitted by the voucher and kept the difference herself. The evidence of theft depended on the difference between the amount Horizon showed had been entered onto the system and the lesser amount of the voucher. Ms. Brennan admitted the discrepancies. She said that they were errors on her part because of problems at home and pressures of work. She denied theft and said she did not know what had happened to the money. Post Office accepts that this was an unexplained shortfall case and that evidence from Horizon was essential to Ms. Brennan's case. Her explanation was that she must have made keystroke errors when entering voucher amounts onto Horizon. The prosecution did not consider whether a bug, error or defect could have affected this process. There is nothing to indicate that any ARQ data was obtained at the time of the criminal proceedings. There was no evidence to corroborate the Horizon evidence. The issue at trial was dishonesty, but there was insufficient proof of an appropriation. It goes on to say that the Post Office had conceded that the prosecution was unfair for ground 1 abuse, but the Court of Appeal Criminal Division found that it was also an affront to justice, ground 2 abuse, and public interest require the Court of Appeal to mark the latter conclusion. And so the conviction was quashed on the basis of both ground 1 and ground 2 abuses. Before I turn to look at the case, is there any reflections you have or what thoughts you had arising from the decision in Hamilton?
I think the decision was right. I'd like to take this opportunity to apologise to Lisa Brennan for being any part in the prosecution of her and all for the harm that it clearly has caused her, and that I'm really pleased that her conviction's been overturned, and I hope she gets the compensation she deserves. But I really didn't know that the system was unreliable at the time that I had any part in her prosecution, but I'm still really sorry.
I want to start by looking at some of the evidence that was before the court, and if we could bring up your witness statement at paragraph 38, please. It's page 18. So you set out at paragraph 38 what you received as a case file to do, I think, step one, the initial review. And you refer to, we don't need to go to all these, but a memorandum by Steve Bradshaw. As we're introducing this case, could you just explain who Steve Bradshaw was?
So Steve Bradshaw was the investigating officer in the case.
We then have Steve Bradshaw's summary of investigation, an antecedents form, and then we have summaries of the interview, and there's two references there to which we'll turn in a moment. If we can go over the page, please. You say it was not uncommon for further summaries of the interviews to be created on request of either the prosecution or the defence. An administrator in the security and investigation team would typically listen to the tape and produce a new summary, clarifying the point in question. You cannot recall exactly which version of these documents you would have reviewed in this file, and you refer to the documents we'll turn to in a moment, and you go on to say that a full transcript may have been available, but it's unlikely to be provided with the case file at the time.
Correct.
I want to start first with the full transcript, or as it's been put in there, the full transcript. Can we please bring up POL 000473220, and that's tab B1 in your bundle. The top, we see this is the record of tape-recorded interview. It runs to 25 pages. This is the document I understand you say was the full transcript.
I think so, yes. It looks like a full transcript.
In metadata that has been provided by the post office, so data that, as to how it's saved on an electronic document, it states that this document name was tape transcript.1, with the date of the document being 18th June 2002. So, if that is accurate, some 5 days after the interview.
That sounds correct. I can't argue with that.
Could we bring up, please, POL 00047322, and that's B2 in your bundle. Now, this document at the top says summary record of tape recorded interview. Are you familiar with this? You're familiar with this type of document?
Yes.
Could you just explain in summary terms how how the summary record of a tape-recorded interview would fit into your work in reviewing the case.
I would review whichever version of the document was in the file when the investigator sent it to me. And what I can't say is which version of the interview was in the file when it came to me.
This document runs to 12 pages. And again, in metadata provided by the Post Office, it states that the file title is summary tape transcript.1.doc with a date of 19th of June 2002. So if that's accurate, does it seem fair to say that a transcript was made initially on the 18th of June and then this summary record was produced shortly afterwards?
I really don't know. I think the only person who can answer that question will probably be Steve Bradshaw.
So that was going to be my next question. It would be Steve Bradshaw who produced this.
I think so, or someone in their admin team. I can't remember now whether the investigation officer prepared any versions of the summary or whether it was all done by one of their admin people. I really don't know what was happening at that time.
Please could we bring up Poll 000475521, and that's B31 in your bundle. This is another summary record of tape-recorded interview, the other one to which you referred. It's shorter at 10 pages. Do you agree?
I can count. 1, 2,
There's page numbers
4,
in the bottom.
5, 6, 7, 8, 9, 10. Yes, it's a 10-page summary, yes.
And the metadata provided by the Post Office states that the file title is amended.summary of tape transcript 1 with a date of 22nd of July 2003.
If you tell me, yes, this means nothing to me, all I can say is I can see the 3 different versions of the summary of tape-recorded interview. I don't know which one was prepared first or in which order. All I can say is that I would have looked at the one that was in the file when I came to advise on the file, but I can give you no explanations why, which ones were prepared first and why. I haven't got enough information to help you on that.
That document can come down for the time being. If we assume that the timeline is accurate, that timeline is accurate, and we have a summary of interview done on the 19th of June, and then there's an amended summary done on the 22nd of July in the run-up to the trial, can you think of any reason why there would be a need for an amended transcript of interview in the run-up to trial? Sorry, amended summary of the interview in the run-up to trial.
Usually how it worked was you'd have the shorter summary of tape-recorded interview when you first had the file, and then frequently the lawyer in the criminal law team, or certainly myself, if I felt that there was not something covered in the summary, I might go back to the investigator and say, elaborate on this point. Sometimes it might be prosecution counsel would ask for fuller versions, and sometimes it came from the defence. But it was not uncommon for there to be different versions. And I really don't know. I can't talk about the timeline as to the production of these summaries. I think you really have to ask Steve Bradshaw that.
Please, could we look at Poll 000475502? It's B19 in your bundle. This is a list of exhibits. If we could go to the bottom, please. Thank you. Number 37, SB12, so that's an exhibit to Stephen Bradshaw's statement. Would you agree?
Yes.
It says typed copy of interview.
Yes.
Do you know, well, firstly, can you recollect whether a summary would have been put forward to court or the full transcript would have been put forward?
I really don't know. If I could see the full bundle of exhibits, I'll be able to help you on that. I don't know whether Steve Bradshaw's statement helps. Does it say how many pages were in his summary?
We can, if we take down that document. Unfortunately, we're going to have to bring up two documents at the same time. It's POL 000475006, and that's B23 in your bundle. And if at the same time we could have POL 000475007. Just bear with us a moment while those documents are shown.
Can I move this for you? Sir?
Please, yes.
Is that better for you or worse?
It is better, but I'm still going to look at paper.
Okay, sure.
I'll introduce this document while we're waiting for the second page. This is an unsigned statement of Stephen Bradshaw dated the 3rd of March. You see on the right, that's the first page of it. We see on the left there's another page. It appears to run together. So we see Ms. Brennan explained the procedure. If an error was made, the reversal process to rectify this mistake was also explained. She did clarify if she paid out the amount indicated on the horizon screen or the amount of the voucher. At the very bottom of in your bundle B24, on our screens, the left-hand side, POL 000475007, it says that a typed copy of the interview is produced as Exhibit TB/12. So that's what we have.
Exhibit SB12.
SB12.
Yeah, that's his exhibit,
Yes. So that's, you asked to see the statement.
Yes,
that's just
thank
so you
you,
can see
yes.
that.
So he's not saying how many pages and which version of the summary that he is producing.
In terms of normal practice in the post office, what would you expect to be relied on or filed with court, the full transcript or a summary?
It depends whether the defence had agreed a summary of tape-recorded interview, and if that was agreed and a transcript wasn't necessary, because sometimes there are things in a full transcript that both sides don't want mentioned. So it really would depend on the case. But in terms of fairness, if the defendant wanted the whole transcript to be put in the exhibit bundle, that's what I'd expect. And if I felt that was relevant, that's what I'd expect.
So when you looked at these summaries, or when you had the charging decision to make, how often would you yourself request the full interview transcript rather than the summary?
I really can't remember how many times I did, but I'm sure there were occasions that I did.
Would you be concerned if there was a material discrepancy between the summary prepared by an investigator and the full transcript?
Definitely.
Can we look at both of the summaries? I want to just compare the summaries first. And so if we can again have two documents up at the same time, it's POL 000-47521 and POL 000-47322. And it's B31 and B2 in your bundle. And if we can please turn to page 7 on the one ending 21, please.
Is that B2?
I'm
or...
so sorry, I realize, yes, if you can pretend to page 7 in, it might be easier actually if you remove the document from the second tab and held it next to, so that in B2.
So that's, you want me to have B31 out of the file, yes?
B31 and B2. So you can compare them together if you can't see them on the screen in front of you.
Yeah, happy with that. And page 7 of which one?
So in the document ending 221, if you could turn to page 7 of that, please. And in the document ending 22, please could we turn to page 8. So in the document ending 2.1, which is on the right of our screens in the hearing, if we could highlight the time counter tapes at 31, please. Thank you. This is from the amended document, and we see it says SB, Mr. Bradshaw. But don't you think a clerk with 13 years' experience, it's a bit, no, there's an explanation. I'll show you this, it's a printout. You know the pensions go through Lisa Halley, and it goes on. At 31 in 2.2 on the left, we see there's more text there.
Yes.
But don't you think a clerk with 13 years' experience, it's a bit, no, there's an explanation. I don't think it's just being careless and pressing the wrong key twice. It's happening too often. I'll show you. It's a printout, you know. Pensions go through Lisa Halley to be checked and sealed off. And if we look at 32 again on 2.2, sorry, so on the left side of our screens, 22, at point in time 32, Mr. Bradshaw is reported as saying it's not careless. Over the page in the amended version at 21, the reference to Mr. Bradshaw saying it's not careless isn't there. Do you accept that?
I can see there are two different versions. Yeah.
If we can turn into one, I know it's we're there. Sorry. It says. Actually, we can leave that there. Actually, can I ask you this? Why would those references to, or can you think of a reason why those references to Mr. Bradshaw saying it's not careless be excluded from the amended interview script?
I really can't answer for the different versions of the tape-recorded interview produced by Steve Bradshaw or the investigation team, and I don't know which ones that I would have seen and when, nor can I tell from what I've seen today which one would have been in the bundle of exhibits. But personally, I would have expected the full version to be in the bundle of exhibits.
Do you think you would have had any involvement in, so you can't answer whether or not you would have you were involved in these actual amendments?
I really don't know.
If you'd been approached and asked to approve those amendments, would you have?
Only if it was going from the shorter summary to the longer summary. I would not have approved it going the other way, from the longer summary to the shorter summary. That's not the way it usually worked. It was usually the officer trying to get away with doing the shortest summary as possible, and legal services coming back and saying there's much more that should go in here. But because I haven't got all my advices and all the paperwork, I can't see whether it was me who picked him up on that, or whether there was some kind of quality and control within the investigation team. I really can't answer that. I don't know.
We'll move on then from that. Can we leave up POL 47322, that's B2, and can we also bring up POL 000473320, which is B1 in your bundle? Thank you. And so just for the record, in the hearing room, we have POL 000473322 on the left, and the POL 000473320 on the right. On 47322, the left document, please can we turn to page 2? At 9, it says it was explained to Miss Brennan why we were at the office. She was asked to explain how she would pay out a pension and allowance voucher. She demonstrated that she had the knowledge to pay out correctly, and she could explain the procedure when rectifying any mistakes. And Please could we go to page 7 on the document on the right, 47320. Actually, sorry, page 6, if we can start there. Thank you. It starts at 9 with a discussion of annual leave. And Mr. Bradshaw's recorded saying, as I said to you earlier, we want to talk about some pension and allowance discrepancies because other people have to listen to the tape. Can you just go through how you would pay a normal pension voucher out? If you can go over the page, please. Thank you. And at the 11, Mr. Bradshaw says, say when you've done this, you've made a mistake and you don't know you've put the wrong amount in. You may have put 2 dockets instead of 1 and you're paying out. The machine's showing £200, but you've only got £100, but the machine's telling you to pay £200. Is there a way of correcting that mistake? Ms. Brennan replies, bin it and get the book back off them. So Bradshaw goes on to say, well, he gives an explanation of a procedure. Ms. Brennan questions that, says, what do you mean? And Mr. Bradshaw says, reversals. Do you know how to do a reversal? If we go over the page, please. Ms. Brennan says, oh yeah, what do you mean? If you're checking the dockets and the dockets are wrong. Mr. Bradshaw, yeah, to see if the dockets are wrong. When you check your dockets and you find that one is wrong, the wrong amount. Brennan says, yeah. Mr. Bradshaw, that you paid and you haven't got, it's gone in the machine. How would you correct that? Ms. Brennan says, go to reversals. Mr. Bradshaw says, do you know how to do a reversal? Ms. Brennan's reply is, I think so, yeah, I presume I do. If I didn't, I'd just ask someone. Mr. Bradshaw, yeah. Have you ever done one? Ms. Brennan, I don't know, probably. Do you think the summary fairly reflects what is said in the interview when it's summarised by saying that Ms. Brennan demonstrated that she had the knowledge to pay out correctly and she could explain the procedure when rectifying any mistakes?
No.
Why wasn't that picked up on?
As I keep saying, I don't know which version of the summary that I had before me when I gave the various advices, and I don't know which version of the summary made it into the exhibit bundle. I really don't know which versions I've seen and which versions I saw at which stage and which versions made it into the exhibit bundle. I really can't say. I don't know. This 25, 26 version is obviously the better version, and I would have hoped that that was the one that was put before the courts. I'm pretty sure it would have been.
Assuming the chronology, which I said earlier, that there's a full transcript on the 18th of June, a longer summary on the 19th of June, 2002, and then an amended summary on the 22nd of July 2003 in the run-up to trial. If that chronology is right, does that tell you about which one may have been more likely
I'm sorry,
to
I
win?
really cannot answer these questions. I really don't know. The only person who would know is Steve Bradshaw.
Let's look at the reliance on horizon data then. Please can we look at your witness statement at paragraph 39 onwards? Sorry, that's page 19, sorry. Actually, yeah, that's perfect. Thank you. Let's actually look at paragraph 40. You say, on review of the file, I would have noticed that the only direct evidence of apprenticeship fraud was contained in the Horizon data discrepancies. As explained above, I had no reason to doubt the accuracy of these discrepancies. You go on to say, initially, I did not think there was enough evidence to support the explanation for these discrepancies, being that Ms. Brennan had intentionally carried out a fraud. And you set out your concerns in a memo to Stephen Bradshaw, which we don't need to turn to, because you say in your witness evidence at 41 that in the memorandum you did not request any details about whether Horizon was operating accurately, because I assumed it was, and Ms. Brennan had not questioned the accuracy of the data in her interview. If she had, or if I had any reason to doubt the Horizon system, I would have asked for the accuracy of the data to be checked in addition to the other points raised. Is it fair to say then, in order for Post Office, or in a case you were advising on, in order for you to advise the Post Office to investigate the accuracy or reliability of Horizon, it was up to the sub-postmaster to raise whether the data was accurate or not?
If I had a whiff that the system was not working reliably, I would have requested that evidence. One of the way I might have got a whiff there as a potential issue would have been the defendant raising it as an issue. I don't think I'd had any cases where it had been an issue, so I believed it was working properly. Miss Brennan didn't raise it as an issue in her interview, because if she had, I would have requested that. In any event, when it came to my advice of, I think it was the 13th of November, I'm pretty sure that I did ask for a statement saying whether the system was operating properly. And I've asked repeatedly for a copy of that memorandum, and it's not been disclosed to me.
Well, let's look at that. It starts, I think it starts at paragraph 58 of your statement. Page 25, please. You said, my advice would have included any further steps that could be carried out by investigators to improve the likelihood of conviction. For example, it appears from question 20.3 of the request that I requested a witness statement confirming the accuracy of the Horizon data. You say something similar at paragraph 70, page 29. Say in his memorandum, referring to Mr. Bradshaw here, dated 14th March 2003, Steve Bradshaw says, concerning point 4 of your memo, dated 13th November 2002, I have spoken to Sonia Cassidy at Lishally in Northern Ireland. She informs me that this type of statement is not normally done, and the matter has been discussed previously with Colin Justice. And you say, I believe he's essentially saying that it has not been possible to have a witness statement drafted by a representative of the Department of Social Security confirming the accuracy of the Horizon data, as I requested in my 13th November 2002 memorandum. The Department of Social Security, their involvement, as I understand it, but tell me if I'm wrong, is that they would take the data from Horizon and compare it to vouchers that had been sent to them, pension vouchers, and notice if there was a discrepancy. And that's what started the investigation.
Yes.
but they were not responsible for the Horizon IT system. That was Fujitsu.
Yes.
So do you accept that this point here, requesting a witness statement from the Department of Social Security, wasn't relevant to the accuracy of the Horizon data or its reliability?
Firstly, I'm not sure whether I just said broadly a statement confirming the accuracy of the Horizon data and any respects in which it was not working properly. I don't know whether I said that or whether I specifically asked for a statement from Lisa Halley. I know that there is this reference here that Sonia Cassidy, having had a conversation with Colin Justice, that's reported back by Steve Bradshaw. But the way I looked at it was something I would have got advice from counsel on, because I'm pretty sure that post-committal, when I did my instructions to counsel to advise on the evidence in the case, if there was any evidence that I had asked the investigating officer for that he hadn't submitted, I would have tried to get a second opinion from counsel to say, do we need a statement confirming the accuracy of the evidence? And I don't know, because I can't see my instructions to counsel or even see my memo from the 13th of November, whether there was any conversation as to the best place to get that statement. So I would love to see my memo of the 13th of November. I would also love to see my instructions to counsel to advise on the evidence. And I would also love to see any attendance notes about the conference with counsel up in Liverpool, which I didn't attend.
Well, we know that there wasn't evidence led on the integrity of the Horizon data. Your evidence is that you'd no reason to believe that there was any problems with it. You say that Ms. Brennan didn't raise any issues with it. You referred to this example here with Lisa Halley about whether, approaching the Department of Social Security. Is your evidence that you think you likely would have sought further evidence on the accuracy of the Horizon?
If counsel thought it was necessary.
So your evidence is that you would have asked counsel's advice?
Yes, definitely. Because what I did, I know that I always did, when I was doing my instructions to counsel to advise on the evidence, I would look at my original advice to the investigating officer and I would see whether he'd ticked all the boxes that I'd asked him to. If he hadn't ticked all the boxes that I'd asked him to, and it was something that I still personally thought was necessary, I'd get a second opinion from counsel, so then I could come back to the officer and say, well, counsel agrees with me, we do need this statement, so please go and get it.
We have an incomplete document base, we know that. We do. On the documents you've seen, can you point to anything where you say to an investigator or otherwise, we need evidence on the accuracy of the Horizon IT system?
No, because I haven't been given the complete set of documents and my solicitors have asked for further documentation and specifically asked for these kinds of things. Yes. And they've not been disclosed.
So, but your evidence is you think...
I'm pretty sure, because that's how I worked. I'm a real belt and braces girl, and I'm the kind of person who would check what I originally asked for, what the investigator has provided, and if there's any question mark, any doubts, I would have got a second opinion from counsel. And I do remember that's how I worked. I'm quite systematic and meticulous.
So I'm clear about this, Mrs. Williamson. The way I read your paragraph 58 is that although the documentation before you, as everyone accepts, is incomplete, your conclusion is that you did ask for a statement, quotes, confirming the accuracy of the Horizon data.
Yes, sir, but I don't know whether I asked for it from Fujitsu or from Lisa Halley when I initially advised on the 13th of November.
But I'd be right in thinking that you did ask for that evidence.
Definitely.
So far as we can tell, it was not forthcoming. Is that fair?
It looks like it wasn't forthcoming because there is this comment on that memo from Steve Bradshaw referring to a conversation between Sonia Cassidy and Colin Justice, to which I wasn't party to.
Exactly.
But I would have... Sorry.
On your evidence, you have reached the conclusion that you did ask for the evidence, and your conclusion is, based on what you've seen, that it probably wasn't provided. Now, we can ask Mr. Bradshaw about this as well, but have I fairly summarized your evidence?
I think so, yes.
Fine, thank you.
There's one further document I'd like to take you to on this issue. It's the witness list. It's in your bundle at B21. It's POL 000-47504. And page 2, please. Thank you. Witness 10 is Denise Johnson, paid order unit, 28 Temple Road, Lisa Halley, County Derry. So it seems that you did eventually obtain some evidence from Lisa Halley.
Lots of evidence from Lisa Halley, because a lot of these witnesses are from Lisa Halley. All these civil servants, they are from Lisa Halley, particularly all the ones with Northern Ireland addresses and postcodes. And if you look at the list of exhibits, a lot of the exhibits in the cases are Lisa Halley producing, I think they call them 205A schedules. So if you look at all those, certainly all the 205A schedules are produced by Lisa Halley. I think the P2311Bs may also be produced by Lisa Halley. I'm just looking at the initials of the witnesses. G-O, who's she?
I can bring it up on screen. It's POL 000-47502.
Yes, so looking at all those P2311Bs, they're all produced by Lisa Halley, mainly by, it looks like, someone called Gerard Moran and someone with a G-O initial who I can't find on the witness list. Then VL, Valerie Long, again, she's a civil servant, and I'm pretty sure she's from Lisa Halley. K-O.
So your point is that what you're making, there's a number of witnesses who were from Lisa Halley dealing with other matters.
Yeah, so who are producing, in effect, schedules that they've printed off from the Horizon system. Yeah, so I think all the first 23 documents on the list of exhibits are all things that Lisa Halley witnesses produced.
Thank you. That document can come down. Thank you. Very briefly on disclosure, we only have draft disclosure statements in this case. You say you would have had a role to play in reviewing those.
Yes.
Could you summarise what that was, please?
So usually there would be the schedule of non-sensitive unused material, the schedule of sensitive unused material, and the investigating officer's report on the unused material, all those would have been sent to me at the time of the committal papers were being prepared. So what I would have done is, my first job would have been looking at the committal papers, looking at the statements and the exhibits, firstly to satisfy myself that there was a case to answer to go to the Crown Court. Then, having looked at that, I would then look through the schedules that the officer had prepared to make sure he had included everything on it that I was aware of. So everything that wasn't already a statement or an exhibit. And I would also, to make sure he'd done his job properly, I would also read through the investigation officer's file to see whether there's any references or any documents that have not been listed as exhibits or statements or unused material. And then if there was anything I was aware of, I'd go back to the officer and say, well, you know, it's not listed, can I have a copy of it? And make sure it gets listed on the right schedule. And then my next job at committal would be, is there anything that undermines the prosecution case, or with reference to the interview, anything that may assist the defence?
At the time, did you think it likely that Post Office held or had access to documents that would tend to support or disprove the support or undermine the integrity and reliability of the Horizon IT system?
No, I didn't. Otherwise, I would have asked for them.
We discussed earlier your involvement in the advising on the contract, so that the Post Office had access to Fujitsu data. You presumably thought that Fujitsu would have had documentation relevant to the integrity of the Horizon system.
If necessary, yes. So that's why I originally asked for a statement about whether the system was operating properly. I don't know whether I asked from the right place, but that's evidence that could have been obtained if necessary.
Did you make any inquiries as to whether there were documents held by Fujitsu or Post Office that tended to support or undermine the integrity of the Horizon IT system?
No, because I didn't think it was necessary in this case, and I thought that's something that the investigation officer would do, because they gathered the evidence. We advised on the evidence on the basis of the material that they disclosed to us and the information that we had. And then, obviously, the investigation manager, National Investigation Manager, advised whether there should be a prosecution.
Your evidence earlier in respect of getting a statement on the accuracy of the system, my understanding of that is you thought it was important, or it was an option to get a statement such as that. I
wouldn't have asked for it if I didn't think it was necessary.
So why didn't you do the same for documentation?
Which documentation?
A documentation relevant to the accuracy of the Horizon IT system.
Because I'm pretty sure I would have asked counsel whether we needed a statement from anyone else to prove the accuracy of the system. And I really, because I haven't got the rest of the documents and I wasn't at the conference of the council, I can only assume it wasn't thought necessary in this particular case.
So that's a statement, whether a statement was necessary to prove it. But in terms of Post Office and understanding the documents to which it had access, which may support or undermine the integrity of the Horizon IT system, what, if any, queries did you make as to what Post Office or Fujitsu held in respect of that documentation?
If you're asking me with the benefit of hindsight, with all the documents that I now know exist, which I didn't know existed until 2009, obviously I should have requested such a statement. But at that time, back in 2002, 2003, I didn't know one, I didn't know the system was unreliable, and two, I didn't know all these various documents existed and could be produced, because if I did, I would have asked for them. I really didn't know. It's one of those things you don't know what you don't know.
I took you earlier to Mr. Bradshaw's draft statement. There's a brief question on that. To what extent, if at all, would you have been involved in drafting those statements?
No. The investigation officer drafted his own statements and he did the statements of the witnesses together with the witness.
Please can we turn to paragraph 81 of your statement? It's page 32. You say that it is also clear that there were more structural problems with the working culture at the post office that prevented the open and transparent sharing of information. It was very hierarchical and there was limited communications between the different strata of the organisation. Even the criminal law team adopted a culture in which we typically kept our work to ourselves and did not communicate openly as a wider team. I think this undoubtedly played a part in ensuring that the issues with Horizon were obstructed for so long. Where you refer there to the more structural problems with the working culture at the post office, could you just expand on what those structural problems were?
Okay, so I'll start at the top. So say, for example, the Post Office Board. The Post Office Board, from what I've read in the various judgments, clearly knew that there were problems with the Horizon system, and that information was not shared further down to the ordinary lawyers within the criminal law team. Then you look at other people high up within the post office, some of whom you may have heard from giving evidence. I don't know, because I haven't been reading the evidence, but I can see from the various transcripts and summaries and also from the 2009 Computer Weekly article that there were people high up in the post office who did know things, and again, that was not shared with the criminal law team. Then I think about people within legal services as a whole. So say, for example, people in the company and commercial teams would not have shared information unless it was necessary with people in the criminal law team. And then right at the bottom in legal services were the criminal law team, because as usual, criminal lawyers are kind of looked down on by other lawyers within the department. Very little was shared with us unless they wanted our help on, say, for example, me helping them with that little section of the agreement about being able to get statements and not being charged too much. And then with our own team, it just wasn't something that happened. We didn't sit down and have discussions on cases and general issues. It's something that did happen in the employment law team. We used to have a sort of like a weekly one-to-one on a Monday morning where people did raise cases and did raise issues, but that's not something I remember happening in the criminal law team. It was very different.
Thank you. So that concludes my questions. Unless you have any questions first, I can see if any of the co-participants have any.
No, I don't have any.
No, it's a nil return in here, sir.
Right. Well, I'd like to thank you very much, Mrs. Williamson, for first of all making a detailed statement, and indeed for pointing out that documentation in relation to aspects of your evidence is incomplete. I'm not saying that we will find that additional documentation, but we'll certainly do our best to try and locate it if we can, even at this late stage. And I'd like to thank you too for answering all the questions that you have this morning. So I think that concludes today's proceedings. Yes, Mr. Stevens?
That's correct, sir. And we're back on Friday at 10 o'clock.
Yeah, all right then. So I'll see everyone then. Bye.
Thank you, sir.